and welcome to the Hudson Institute. My name is Devlin Hartline, and I'm a senior fellow at Hudson's Forum for Intellectual Property. I'm thrilled to be here today with three expert panelists to take a deep dive into the law and policy issues at the intersection of copyright protection and artificial intelligence. In particular, we'll be examining a report issued by the U.S. Copyright Office earlier this month on the legality of using copyrighted works to train and develop generative AI models. These models, such as ChatGPT, Claude, Copilot, and Midjourney, have taken the world by storm over the past few years. And these tools allow users to create all sorts of wonderful content, from drafting emails and designing artwork to composing music and writing computer code. It's almost like magic. And all it takes is a simple textual prompt to produce something that's quite polished. There's also downsides with generative AI. For example, it sometimes hallucinates things and it spits out false or misleading information. And of course, the reason we're here today is because it raises significant legal and ethical concerns with respect to intellectual property rights, including copyrights. The U.S. Copyright Office began examining these issues in early 2023. It initially released a policy statement expressing its views on the protectability and thus the registrability of works created with generative AI. The Copyright Office administers the copyright registration system, and applicants were claiming works that were either created by or created with the assistance of AI systems. And so this guidance was sorely needed. The office has also been conducting a longer study that has produced 3 reports so far. The first report tackles the problem of digital replicas or deepfakes, which is where AI replicates a person's voice or appearance for some nefarious purpose. And the office suggests that Congress should pass legislation to address this issue. The second report covers the copyrightability of the outputs generated by AI systems. And the focus here is on the human authorship requirement. So there must be sufficient level of human contribution for these outputs to be protectable. The office is apparently working on a 4th report that will examine the flip side of this issue. So not whether the outputs are protectable, but whether they are infringing. But it's the Copyright Office's 3rd report, which was published on May 9th, that brings us here today. And this one looks behind the curtain to see how the magic trick is done. So the latest report is probably the most significant one for copyright owners because it addresses whether the use of their protected works to train these AI machines is either copyright infringement or fair use. And this issue is being litigated in over 40 high-profile cases. And the parties on both sides and copyright owners everywhere have been anxiously awaiting for the Copyright Office, which is the government's leading agency on all things copyright, to weigh in. And so to discuss these important issues, we have 3 expert panelists here with us today. We have Bob Brown-Ice, who is the Michael J. McKeon Professor of Intellectual Property Law at George Washington University Law School. We have Kevin Madigan, who is Senior Vice President, Policy and Government Affairs at the Copyright Alliance. And we have Reagan Smith, who is Senior Vice President and General Counsel at the News Media Alliance. So our discussion over this hour is going to cover a lot of ground, including the background issues on how the report was developed, the content of the report itself, and the takeaways from the report, including its implications for these ongoing lawsuits over generative AI training. So I'd like to thank the panelists again for being here today. And to kick things off, I want to address the first question to Reagan. Hi, Reagan. So, before you were at the News Media Alliance, you previously served as the General Counsel and Associate Register of Copyrights at the Copyright Office. So you have a unique insight into how these reports get made. So can you walk us through what's the Copyright Office's authority to produce these reports, and how are they produced behind the scenes?
Yes, and thank you again for having me and for hosting this. I think explaining what the Copyright Office does with its reports is a really good first question. And when I was at the Copyright Office, I really had the privilege of leading or working on several of these policy reports to Congress, ranging from Section 1201 of the DMCA to music matters to registration issues to exceptions and limitations, including fair use or compulsory licensing or library uses. So you can see these are pretty, routine projects for the Copyright Office to take on, although they are big projects, and they are rooted in Section 701 of the Copyright Act, which tells the Copyright Office that they need to conduct studies and also provide advice to Congress. And so in this case, the second footnote of the report says that they were responding to a direct request from the Senate Judiciary Committee. And given sort of the explosion and interest in AI, you see some follow-up that went on a bicameral basis throughout the process of their reports. So there's a long history of how the Copyright Office conducts the reports and how they are received. So the Supreme Court has mentioned this a couple times in Mills Music. It talks about how the Copyright Office reports formed the backbone of the legislative history for the 76 Act. Other reports gave way to the Copyright Claims Board or aspects of the Music Modernization Act. And these reports are frequently cited by the judiciary, up to and including the Supreme Court level, when the courts may find the office's authority persuasive. And so they typically would get Skidmore deference, just by their power to persuade, which I think is potentially relevant here. They're large undertakings process-wise, and in this case, the office issued notice and comment. It got over 10,000 comments, and it had a limited series of ex parte meetings where you can sort of see who the office was speaking with throughout the course of this. And then they take all this input, synthesize it, and provide their analysis and recommendations to Congress and to policymakers. And if I can, I'll just want to say, one more thing, because I got some questions on this particular report since it was released. In my experience at the Copyright Office, it's actually very typical for that agency to be asked to speak as to broader fair use discussions, even outside of a specific litigation context. So the report says, we all know fair use is going to be evaluated on a case-by-case basis, but that doesn't mean that we don't want the government to talk about the underlying legal concepts or public policy drivers of fair use. And so the Copyright Office is recognized as having some special expertise in these issues. So they are also told to operate the Fair Use Index, which is a way of teaching lay people fair use decisions that develop from time to time. And the Copyright Office leads the Section 1201 rulemaking every 3 years, which in itself is sort of a set of mini proceedings on whether uses are likely to be fair or non-infringing, breaking down technologies and drawing inferences and contours, not really unlike some of the ways it's handled this report. There's other advocacy and congressional responses, and I'm sure other examples. So overall, the sort of process and way this report was put together actually feels very vintage Copyright Office to me.
Did I read correctly that there was 10,000 comments filed as part of this study? And does somebody at the office actually have to read all these? Wow.
Oh yeah, you have to be very organized and put this all together. But I think that's part of the office is taking this charge seriously, given the impact of AI on the copyright ecosphere. Yeah,
well, and I'm sure that Kevin and Bob feel the same way. But I've read probably every report the Copyright Office has ever put out, and it's always top-notch analysis. So yeah, but it's a lot of work. So anyway, it's a super interesting report. But Bob, I want to ask you, I have to address the elephant in the room, because there's some strange circumstances in which this third report on generative AI training was released. So what is happening right now at the Library of Congress and the Copyright Office?
Well, first, thank you, Devlin, for holding this webinar and for inviting me. Well, you mentioned that the report was issued on May the 9th. And probably most people in the audience know that the president fired the Librarian of Congress, Dr. Carla Hayden, on the evening of Thursday, May the 8th, so the day before the report was released. The report was then released in a special pre-publication version on the 9th, and then the succeeding day, Saturday, May 10th, the president fired, or purported at least to fire, the Register of Copyrights Chair Perlmutter. And obviously the timing of Part 3's release and also its special release in a pre-publication version has led to a lot of speculation of whether and how it was connected to Register Perlmutter's dismissal. There's been some public speculation that Chair Perlmutter was fired because of the release of a report that didn't take a completely tech company friendly position. If I had to guess, I'd actually guess that the causation was the other way around, that Register Perlmutter, guessing that she might be next in line after the librarian was fired, wanted to ensure that a report that, as Reagan mentions, the Copyright Office had been working on for almost 2 years and that was substantially complete, would be published before she was fired, if that was going to happen. I also think it's possible that the timing was connected with movement in some of the AI copyright litigation. Yes, the report is directed to Congress, but obviously the Copyright Office, like everyone else, recognizes that there's ongoing litigation and that the litigants and the courts might benefit from the Copyright Office background. And by the way, the background that the Copyright Office collects from those 10,000 comments, right, as in thinking through those fair use issues. So there had just been oral argument on the fair use issue in one of those cases, Kadri versus Meta, on May the 1st. And it would make sense that the Copyright Office would want the courts and parties in that litigation to have the benefit of its report. So all that speculation, we may never know exactly what happened. What I think we do know is that the report is now out. It's been released, and that it reflects the position that the Copyright Office developed over its 2-year inquiry. So if the report is now modified or withdrawn, I think we'll know that that's due to subsequent policy maneuverings, not the path that the Copyright Office had been on for 2 years.
Yeah, no, and that, yeah, the timing is super interesting. And I think you're right about the causality being backwards. If you think, that she probably, Shira Perlmutter, the Register, probably released the report knowing that, maybe she was going to be next, that she wasn't fired because she released the report. But correct me if I'm wrong, Bob, but the Librarian of Congress, Dr. Carla Hayden, is not challenging her termination. She was already 9 years into a 10-year term. And I think the legal issues with firing the librarian are different than with firing the Register of Copyrights, who's an inferior officer. And so
that's correct.
Yeah. So so the Register of Perlmutter is challenging her termination, and I think her argument is twofold. That she doesn't say that the librarian couldn't be fired, but she says that President Trump couldn't appoint an acting librarian because of the federal vacancy law, which is beyond my pay grade. But and so then the second step is that she could only be fired by a true acting librarian. Is that the gist of it?
Yeah, that right. That the president can't fire her directly. That it would have to be done by a librarian who was in power to do so. That's correct.
Okay, and I believe so that Register Perlmutter sought a temporary restraining order, which was denied for lack of irreparable harm. And then I think we just found out this morning, or I guess last night, that now she's trying to get maybe summary judgment. And so I think a lot of people will be watching that case, and maybe we'll get some some more interesting constitutional law from the
absolutely that goes way beyond copyright and AI.
Yeah. Yes, it does. So we talked about the 10,000 comments, and so Kevin, I want to ask you, because your organization, the Copyright Alliance, filed comments as part of the office's study. I think maybe even 2 rounds of comments. And so what were the main points that you raised in your comments, and how does generative AI affect the members of your organization?
Yeah, thanks, Devlin, and thanks to you and the Hudson Institute for inviting me to participate. Yeah, so we at the Copyright Alliance submitted initial comments in response to the study, and our comments were actually over 100 pages long. I think we answered just about every one of the Copyright Office's 34 questions and sub-questions, and then we also submitted reply comments that were more focused on past fair use cases and their applicability, excuse me, or inapplicability to generative AI. Now, it's worth pointing out that those comments were filed in October and December of 2023, which seems like a lifetime ago in the age of generative AI. But really, while the landscape has changed and technologies have advanced and more lawsuits have been filed, I think the fundamental points we made in the comments are just as applicable today. And so just to hit a few of those main points, the first is that when formulating new AI laws and policies, we said that it's essential that the rights of creators and copyright owners be respected, and that longstanding copyright laws and policies shouldn't be cast aside in favor of any new laws or policies that would essentially obligate creators to subsidize the development of AI technologies. The second point was just making clear that ingestion of copyrighted material by AI systems implicates the right to reproduce copyrighted works, which was something that the AI developers were arguing against back in 2023, though that has shifted a little bit, which we can probably talk a little more about later. Another important point, again, which I'm sure we'll talk about later, is that we said ingestion of copyrighted material by AI systems is not categorically fair use. The next one is that AI companies should license the works they ingest for training. And then lastly, there should be transparency requirements when it comes to commercial public-facing AI systems about what materials they've ingested. And then to answer the second part of your question about how generative AI training affects our members, it's sort of a tough question to answer because our membership is very broad. It ranges from individual creators to large companies and copyright owners. And also because generative AI models, the effect they have will vary depending on whether it's a large language model, an image generator, a music generator, and so on, and what the purpose of that model is. But I think one thing that's universal is that when a commercial generative AI model is trained on massive amounts of copyrighted works without authorization, all the copyright owners of those works are sort of robbed of their ability to control and be compensated for the use of their works. And loss of compensation can be from actual loss of sales of a work due to an AI-generated substitute, or it can be from lost AI training licensing opportunities, which is something the report also talks about. So I guess just fundamentally, I think copyright owners, they just want to exercise their rights to either say, no, you can't train on my work, or okay, you can, but I want to say in exactly how you use my work, or I want to be compensated for it.
Yeah, thanks. And I have the same question for you, Reagan, because I know that the News Media Alliance also submitted, I believe, 2 sets of comments as part of the study. And so what are the main points that you all raised in your comments, and how does generative AI affect your members?
Thanks. Yeah, and maybe I'll answer the second part first. So News Media Alliance, we have over 2,200 members, which are newspaper, magazine, digital media publishers of all shapes. And AI is having a lot of impact on the media industry. Many of our members are investing in their own uses of AI to facilitate research or efficiency or insights. Many have led the charge in striking partnerships with AI developers to inform their work, helping reduce hallucinations and add insight in a symbiotic way. But in other cases, there's really a unique risk, I think, when some of our members are litigating to combat free riding by generative AI developers. We took a look when AI started exploding, and we realized that news content is disproportionately overweight in the training of LLMs because well-written journalism is especially useful in the training process. So one study of a big data set is called Open Web Text Data Set, is used by OpenAI and others, found that nearly 10% of the URLs came from just 15 premium news publishers. We did our own sort of forensic study, and we found that news content is between 5 to sometimes 100 times overweight in training data sets as compared to Common Crawl, which is kind of like the overall internet. And so in October 2023, we submitted this to the Copyright Office, a white paper that looked at instances of use in training as well as retention and memorization, which I think we'll talk about a little bit more. We also have been very focused on a process called retrieval augmented generation, or RAG, which is really exciting for AI uses. It's when a model queries and extracts content from a separate data source. So you're not training the model, you're using the model to query a different data source. That can be something proprietary that's happening in an enterprise and is under permissive agreements. It can also be a website. So we're seeing instances of so-called answer engines like Perplexity or Google's AI mode, which are no longer being a search engine trying to help you find out where to go on the World Wide Web, but instead it's sort of a one-stop shop. And unfortunately, too often we're seeing trends where news content is just being repurposed to compete against it, without, as Kevin said, sort of the control or possibility of compensation that we would have seen in the past. So we did file fairly comprehensive comments. In addition to that, we offered a fair use analysis for the Copyright Office to consider on training. We highlighted some of the developments because these are publishers or all have internet websites on bot scraping, evasion of access controls, going under paywalls, or violation of terms of use that we were concerned about. And we engaged pretty deeply, I think, as far as licensing, since our members do care deeply about making license scalable, making this feasible and possible for AI developers as well as for themselves. And we have been a strong supporter of voluntary collective licensing. We also touched upon transparency, and I think we too think this should be an area in need of legislative attention.
Great, thanks. So I want to turn to the report itself. And so it starts with a description of how and why they use copyrighted works to develop generative AI models. And so, Bob, this question is for you. Can you take us through the process of creating these AI models? For example, what does it mean for a copyrighted work to be ingested?
Yeah, so I can't take you through the process in all technical detail. That would take us days, but perhaps, and most importantly for copyright purposes, the typical process starts with the model developer making a local copy of all the works it wants to use to train the model. So most models that are currently commercially available had been trained in large parts on works that are scraped from the internet. That is to say, they're downloaded without inquiring into the copyright status of that material or obtaining any license to use them. So if the works are under copyright, then the making of a local copy is arguably a prima facie violation of the reproduction right under Section 106 of the Copyright Act, something that Kevin mentioned in the comments that the Copyright Alliance submitted. So there's after that happens, there's a lot of possible technical detail in what happens next, and we could easily spend the entire day and then some talking about things like tokenization and attention windows and diffusion and convolutional neural networks and all that sort of stuff. But at a very high level, the local copies are then processed by an algorithm that creates a very complex model, right? So in the case of language models, it creates a very complex model of linguistic patterns that are embodied in the works, like grammatical structures, associations between words, word sequences, particular turns of phrase, etc. Sometimes it ends up, as we may talk about, memorizing large chunks of entire works. Sometimes it doesn't. Text-to-image image models do something slightly different, but they also find patterns in images and what patterns might be associated eventually with certain linguistic descriptions. I don't think that that's all that different from how at that level we learn a language or we learn artistic depiction as human beings, right? We also read or listen to a lot of works. And typically we don't remember the works verbatim, right? I read A Tale of Two Cities, but could I recite it to you? No, I can't. But we do remember patterns in the works, and we're able to recombine the patterns in the works we read into new works. That's kind of what I'm doing right now in speaking to you, right? That's at a very high level of the process.
Yeah, well, thanks for that. And I know the other two panelists, their organizations submitted comments, and those comments made it into these reports. But you actually wrote a law review article that was recently published at Columbia, I believe, on the difference between training human authors and training these generative machines. So what's the difference between AI training and human learning?
Well, yes, according to the article I wrote, I think, first of all, there are a lot of similarities, right? So to the extent that the AI developers claim that they are making a different kind of use of the works than human people do, I think that's largely incorrect. I think that we as human beings are not just being entertained by those works, we are learning from them. That's an important purpose of copyright law, right? The Copyright Act of 1790 and the Statute of Anne, they talked about encouragement of learning. They did not talk about encouragement of entertainment. And so in that respect, I think, claiming that there's some kind of AI exceptionalism where the AI developers would get to claim fair use when human beings wouldn't, right? I can't claim that I can go out and make myself an entire copy of a novel that's under copyright because what I want to do is learn from it. We all know that whatever the debate is about fair use, that goes outside of the current boundaries of fair use. It's odd to me that the AI developers would claim that, well, they can do it because somehow it's different. They're doing something different than human learning. To the extent that human learning is different, or human reading, let's say, is different, I actually think that also weighs against fair use. So one of the arguments of the developers, or at least folks who are associated with developers, is that, well, although it's true that when humans make copies, that they are that implicates the reproduction right. What computers are doing really is just reading the works. The copy is a technical matter just because of how computers operate, but they're sort of reading. And when humans read, humans don't violate any of the exclusive rights. Therefore, we should find that AI development doesn't implicate the exclusive rights. And there, I think you have to understand that the entire structure of the exclusive rights of copyright is at root based on human limitations. That is to say, it assumes that in many cases, we as human beings will need copies of works in order to study them at leisure and at length and learn deeply what is in those works. A single performance of a classical work probably for most of us would not be enough to learn the violin line in the classical work, right? We would need the notated fixed work. So because I think AI in its processing of works is in some ways superhuman, it is able, just as a sort of timing matter, through parallel processing and stuff, it's able to extract patterns from works that it would take human beings many lifetimes to extract. I don't think that the AI developers can say, well, making a copy is just a technical thing for us. It's just like reading. Actually, what they're doing is not just like reading. It's something that is sort of goes beyond what I think the differences between the exclusive rights assume. So that's one thing. I also do think that when human beings read something that's publicly available on the internet, we are participants in an entire copyright economy, and our reactions to what we see are likely to cause us to, for example, spend money. Like if I find a musician on the internet and it's something that the musician has freely posted, I may come to like that musician. I'm going to go out buy tickets to her next concert, right? The AI development is entirely out of that ecosystem. In fact, AI developers are sometimes proud in saying that, well, we don't really have any emotional reactions. Our machines don't have emotional reactions to this. We don't remember these things. It's just extracting these details. So being outside that entire ecosystem also means that the machines aren't having the kind of reactions that the folks who posted that material want the possibility of eliciting. And in that respect, I think AI training is also different than human reading.
Wow, it's fascinating. So I recommend people Google your name and find your paper, because it's a truly wonderful paper, and I'm glad the Copyright Office quoted you and cited you in the report. But Reagan, I want to go back to you. And so these things are copy machines, right? So the Copyright Act grants authors the exclusive right, the right to exclude others from making copies. This is the reproduction right. And so what does the Copyright Office report have to say about the copying that occurs? And so is there any doubt that there are reproductions being made?
Yeah, that's a good question, because I think, the report overall is trying to break apart and talk about, different uses, different technologies. It's leaving some room, to have different outcomes, sort of accuser and adventure. But in terms of whether or not there's copies made, this is something where they provide a lot of clarity. And no, there's no doubt that there's, a prima facie, implication of the reproduction right. And part of the reason I think the Copyright Office comes on so strongly on this point is that the stakeholders also agree, right? So no matter what you think, whether or not there's fair use or not, or whether you should come with the ability of the copyright owner to say, no, you can't use my work in the right way. Like everyone is sort of agreeing that there are a lot of copies being made. What I think is useful about the Copyright Office report is they're sort of breaking down where that is happening. And so, Bob, I think you explained fairly, great in the beginning in some of the ingestion places. The office reports, breaks it up a little methodically. There's training, there's pre-training, sometimes there's something called mid-training. There's also the data collection and curation, and that might be a different user who's doing that from the secondary developer who's making copies locally or using this in the training process. You also have even retention potentially in the model. And this part is sort of interesting in the report. They say that model weights that have memorized protectable expression from training data may also infringe the reproduction right, and sometimes perhaps the derivative right. And this is important, again, because it could be different actors. It has some implications for, open source models, which means you sort of share the weights with everyone. And so then they talk about subsequent copying of the model weights. If the weights themselves are deemed to sort of embodied enough copyright expression, could also constitute prima facie infringement. And I looked at the report again this morning before knowing we would have this discussion. It's really kind of interesting how they sort of grapple with some of the academic literature and some of the stakeholder comments. And they say, a model is not like a magical portal where out comes an image after you've given, the name of someone that you want to see their photo. There is in some ways memorization in that instance that is going to qualify under the Copyright Act as an instance of fixation. And then they also separately break up, if I could say for a second, retrieval augmented generation, which, as I mentioned, when you query sort of a separate database, so you've got a different copy of the model, of the copyrighted expression. So even if, setting aside whether a model is learning or something by retaining when it is through the training process, which is a bit of what Professor Brown has talked about with RAG, you just have a sort of separate, discrete set of information that the model is querying on. And the Copyright Office is pretty clear to say that that instance is going to be more likely to be infringing in sort of a separate case because it doesn't raise some of the technological complexity questions, these questions of intermediate copying and so forth that we might get into, and the purposes of the use are too similar to the underlying model. When you're doing a query, tell me what has happened, in whatever you want to learn about in your local news, and then you get a summary out of it based on the underlying article, that is going to have serious implications for copyright.
Yeah, thanks. And so I think, for the non-copyright lawyers that are listening, so prima facie infringement is just that the copyright owner showed that they are the copyright owner, they own the work, and there was an unauthorized copying, which usually the reproduction right, but it could be the derivative right or some other of the exclusive rights. And so what happens is once the copyright owner shows that there's prima facie infringement, it turns to, the billion-dollar question of, okay, is the infringement excused by the fair use doctrine? So fair use says, even if it's infringing, you're not going to be liable for the infringement because it's fair use. And so, Kevin, I want to turn to you. And so there's 4 fair use factors. And so what does the Copyright Office have to say about the first factor, which talks about transformativeness and commerciality?
Yeah, so the factor 1 analysis is a really important part, if not sort of, in my opinion, one of the most important parts of the report. And the reason for that is that in their discussion of transformativeness, they highlight a really important principle that I think some of the courts that are overseeing the AI infringement cases are having a hard time recognizing. And that's that when considering whether a use is transformative, you have to consider what they call the ultimate purpose of the use. And that's a critical part of the first factor analysis that the Supreme Court somewhat recently confirmed in the Warhol v. Goldsmith case a couple of years ago. So for example, AI companies and some of their supporters often argue that training an AI model is highly transformative because the development of a generative model serves a different purpose than that of the works ingested. And I think that's, a lot of people would agree with that. But as the report explains, you can't just stop the analysis there. You have to consider the ultimate purpose of the overall use. So you have to look at what the training is for, and in many instances, it's to generate material that serves the same or very similar purpose as the ingested works. In the report, they give the example of an AI music generator, and they say, I'll quote from the report now, training an audio model on sound recordings for deployment in a system to generate new sound recordings aims to occupy the same space in the market for music and satisfy the same consumer desire for entertainment and enjoyment. So, sort of the ultimate purpose is the same as the ingested works. Now, on the other end of the spectrum, they do talk about AI models that are likely to be found transformative if used for research purposes or content moderation. So really, they say transformativeness is a matter of degree. And like all fair use analyses, it's going to have to be considered on a case-by-case basis. Couple other important conclusions the report makes under the transformative analysis is one of which is, despite what some claim, when a model is used to generate expressive content, it really can't be argued that the use of the copyrighted works is non-expressive and therefore inherently transformative. And then the second one is the report explains that the argument that training is inherently transformative because it's just like human learning fails, one, because fair use does not excuse all unauthorized uses that are for the purpose of human learning, which Professor Brown and I talked a little bit about earlier. And then number 2, AI learning is different from human learning in ways that are really material to a copyright analysis. So that's sort of what they say about transformativeness. And then they move on to commerciality, which is the other big consideration under the first factor. And the report talks about this issue of data laundering, which is when a data set is initially perhaps curated for non-commercial purposes, but is then later adopted for a clearly commercial use. And the report says that because there are often many different actors or entities involved in various stages of the creation of an AI model, it's really important to look at sort of underlying financial relationships between the parties. So for example, if let's say OpenAI funds a nonprofit research entity to develop a data set that's then they later sort of use for a clearly commercial venture, that's probably going to weigh against fair use. Now, the report also talks about how the nonprofit status of an organization shouldn't necessarily be determinative of a finding against commerciality. So it explains that, nonprofits may engage in commercial activity by directly monetizing data sets or models through licensing or subscription-based products. And that kind of direct monetization would be commercial, even if, an organization has technically a nonprofit or charitable corporate structure. And then the last part of the Factor 1 analysis in the report looks at the unlawful access of training material, which is a really important issue in a number of ongoing cases where either evidence has shown or the AI companies themselves have admitted to downloading large data sets from known piracy sites. And the report says that, quote, the knowing use of data sets that consist of pirated or illegally accessed works should weigh against fair use without being determinative. So it'll be sort of interesting to see how courts apply that factor, if they do, alongside transformativeness and commerciality. We've already seen in some cases, the Kadri case that Professor Brown Eyes mentioned earlier, that the judges recognize that there's some bad activity going on here when all these pirated works are being downloaded, but it's sort of they have difficulty incorporating it into their fair use analysis. So perhaps they'll look to this report and consider it under Factor 1. It's also worth reminding that the Warhol v. Goldsmith case clarified that a finding of transformativeness is not controlling of the first factor. So you could think of a scenario where commerciality and the use of pirated material for training might actually outweigh a finding of transformativeness. So, there's sort of a lot in there to digest under the first factor, but it really is, I think, one of the most important parts of the report.
Yeah, and thanks for that, Kevin. And the Supreme Court's recent decision in Warhol v. Goldsmith is huge. It's and like you said, you have to focus on the ultimate purpose of the copying. So it's not just copying at the ingestion stage and that's it. Like, what happens with it? Well, what does the model do? It produces new content. And so I've heard people complain, well, you can't give copyright owners control over this new content if it's non-infringing, but that misses the point, right? The question is whether the outputs are infringing is beside the point. The question is whether it's for a different purpose under the first factor. So it's interesting too, and I know you've written about this, that some of the older cases on fair use that they're pointing to are not necessarily 100% good law after the Supreme Court reiterated, the transformative factor in the Warhol case. So very curious to see what happens there. Reagan, there's the second factor and the third factor, and they don't get a lot of attention in fair use discussions, but they're obviously very important. So what is the report's approach on the nature of the copyrighted works and the amount and substantiality of the portions that are used with these models?
Yes, and that's right. It's common in fair use where the second and third factor get a little less attention than the first and fourth. Maybe not all the times, but that's the case here, and that is commonplace. So factor 2, the nature of the copyrighted works. The office kind of notes that for these generative AI uses, there's such a large amount and variety of training materials that the facts are going to vary depending upon the model and also the works at issues. But, if the work is more expressive or if it's not published, that will help disfavor fair use. But overall, you've kind of got a wide variety of copyrighted materials, and this factor seems to be relatively less important, I think, as a result. So then the third factor is the amount and substantiality of the works that are used. And the office said that there's sort of 3 relevant considerations for factor 3. The amount that has been used overall, the reasonableness of that amount in light of the purpose of the use, and the amount that is made accessible to the public. So the amount, you sort of look at whether you've taken the entire work or the heart of the work. The office cites Harper and Row, where the Supreme Court said taking is not excused just because it is substantial with respect to the infringing work. So you're looking at the first copyrighted work, not what the user has created. If they infringed a lot or they added a lot of their own materials, that's not the way you measure it. For reasonableness in relation to the use, this one is pretty interesting. So they say that they believe that generative AI uses and reasonableness is less clearly justified than in cases of taking whole works for, and they mentioned the Google Books case or some of these internet search cases. We are trying to point to the underlying work and trying to drive a user as a sort of service as a finding aid. That's generative AI is doing something a little bit different. And they also talk about whether for training purposes the use of is necessary. So a lot of the generative AI developers and those who are concerned might say, hey, you don't need one particular copyrighted work for training, you just need a lot. And the office is sort of looking at that in light of some cases involving video game copying, as well as Google Books that have this so-called intermediate copying doctrine, which says that what you really want to consider is not just the amount used overall for the third factor, but how much is ultimately shown to the public. And in that case, the office says, well, we think there's some differences between what's going on in those intermediate copying cases, and particularly the ones involving software. But their logic suggests that the third factor weighs less heavily when there's effective limits on the trained model's ability to output protected material. I think that's kind of honestly in line with how they've looked at the first factor, saying you need to look at the ultimate use. They're also saying that that is true for the third factor as well.
So let's turn to the fourth factor. And Bob, I'm going to ask you about this one. So this is sometimes described as the most important factor, and it looks at the effect of the use on the market for or the value of the copyrighted works. And so this one's really important because it addresses the likelihood that copyright owners will be deprived of certain revenues. So what does the Copyright Office report have to say about market harm?
Yeah, so if I think there's a news flash about the Copyright Office and report and its treatment of the fourth factor, it's that the office comes out in favor of counting not only direct lost sales, but also what it calls market dilution as market harm under the fourth use factor. So just to think about the difference between those two, I think direct lost sales are relatively uncontroversial as a form of market harm or harm to the value of a work that should be counted when determining whether a use is a fair use. So, for example, in the facts of Harper and Row versus The Nation, Harper and Row had a contract with Time magazine where Time was going to pay Harper and Row to license excerpts of President Ford's autobiography. And then The Nation published excerpts of that autobiography without getting permission from anybody. And Time magazine backed out. It said, well, The Nation's already published some of what we wanted to publish. And so we're not going to, we're going to terminate the contract and back out of it. And we're not going to pay Harper and Row what we would have paid, right? That's sort of direct loss sales from infringement. But what about the case in which the generative AI outputs are not substantially similar to any of the training works, but they compete in the same market as the training works? So suppose we train a model with works that are featuring famous detectives, Sherlock Holmes, Hercule Poirot, Philip Marlowe, Sam Spade, Nancy Drew, the Hardy Boys, right, and so on. And then we prompt the model and we say, could you write a detective story featuring a detective who's also a Catholic priest in England? Right, and suppose the model produces some stories about a character named Father Brown, and G.K. Chesterton actually wrote Father Brown, but imagine he didn't write it, right? This is coming out of the model for the first time. And suppose that, yeah, okay, the Father Brown stories, the character and the plot are not really substantially similar to any of the stories we trained on, but we can produce proof that those stories did diminish the market value of some of the training work. So some people who previously bought Sherlock Holmes say, oh, this Father Brown guy, I really like him. I'm going to stop buying any new Sherlock Holmes, of course, there aren't anymore, but new Hardy Boys would probably go on forever. I'm gonna purchase Father Brown stories. So, is that the kind of market harm, which the Copyright Office calls market dilution? Is that cognizable in a fair use analysis? And in some way, you might say, that's an odd question, because if the Father Brown story is not substantially similar to any one Sherlock Holmes story, then why are we even talking about fair use? Because under traditional fair use analysis, like the one in Harper and Row, we presume substantial similarity. We'd say, well, we wouldn't be asking about fair use under Section 107 unless there was prima facie infringement due to substantial similarity under Section 106. But right here, the copying of the Sherlock Holmes as a story, given the facts, hypothetical facts I've just given you, was necessary for the model to learn how to write detective stories. What do we do then? And this comes back to my view. It's not fully embodied in the Copyright Office report, so I'm not going to attribute it to the Copyright Office, but I'm going to say, look, when human authors learn how to write by reading previous works, we don't say that they have a blanket fair use defense to infringement liability if they make unauthorized copies while engaging in that learning. So, for example, G.K. Chesterton himself, right, who actually wrote the Father Brown stories, he was a big fan of Sherlock Holmes and of Arthur Conan Doyle, Sir Arthur Conan Doyle, the British author who wrote those stories. He bought Sherlock Holmes novels, collections of Sherlock Holmes stories, etc. And then he learned about detective stories, and yes, he ended up producing a character and plots that are not substantially similar. But in that copyright ecosystem, it was sort of feeding the last generation of authors with proper compensation for what they were giving to his works. Now, I will say, and this is something that's not in the report, I happen to think that there is a limit here, not on infringement liability, but possibly on the measure of damages, right? So I don't think that every kind of compensation that I receive from a skill that I learned from reading an authorized copy of the book is somehow unjust enrichment damages under that copyright infringement. I think there has to be some limitation there. So I don't think it's true that every profit that might be made from a generative AI output is automatically damages in the copyright infringement suit. But that doesn't mean there's no copyright infringement. It just means the damage would be limited.
Yeah, thanks for that. It's super interesting. It reminds me of how characters are copyrighted, like you're saying. So even if somebody creates a new work with, say, Mickey Mouse, and it's not like a violation of the reproduction right, but it could still violate the copyright in the character of Mickey Mouse, which is separate from the works in which the character appears. And so, but we're getting short on time, so I want to turn to licensing. And so, Kevin, this question will be for you. Assuming that these things are infringement and not fair use. So the AI companies would presumably need to obtain licenses from copyright owners, or else they would be liable. So what does the report identify as like the benefits and challenges with the different licensing options?
Yeah, sure. And then just very quickly, because I know we're short on time, to add to what Professor Brown was saying, when the report talks about lost licensing opportunities for training, they seem to make it unequivocally clear that that is a consideration under the fourth factor, which, some courts are saying that, no, we're not going to consider that. Specifically, the CAD review meta case that we talked about earlier, the judge said that was, the too circular a concept, because if fair use exists, then it wouldn't, but I just wanted to point that out because the report really does make clear that that is something that should be considered. But yeah, so sort of connected to the licensing questioning. The report talks about the benefits of voluntary licensing and the deals between copyright owners and AI companies that have already been struck for training materials. And it says that the licensing market should be permitted to continue to develop without any government intervention. But it does say that there are some concerns about the ability for licensors to respond, at scale. And it says that to the extent that there are remaining gaps, in licensing, they could potentially be filled through alternate solutions, like something called extended collective licensing. And, you know, they briefly touch on antitrust concerns about collective or blanket licensing of copyrighted works. And they note that courts have held that without certain safeguards, there's nothing intrinsically anti-competitive about such licenses. But they sort of conclude by encouraging the Department of Justice to provide guidance, including on the benefit of an antitrust exemption in this context.
Great, thanks. And so I think a big problem is going to be, if they're scraping the internet, and almost everything is going to be copyrighted if it meets the low originality threshold. It's going to be tricky to find people that could even give you a license. And then the question is, are they even going to want to give you a license if you offer to take one? So I'm curious to see what happens with all the licensing issues. Bob, I want to go back to you. And so there are dozens of lawsuits, I believe over 40 of them. And the Copyright Office report doesn't really discuss them directly, but I believe that plaintiffs and defendants in these cases are already citing the report. So what's in the report that supports the AI companies, and what's in there that helps the copyright owners?
So I think in terms of the currently prominent lawsuits, I think the report mainly supports the position of the plaintiffs. And that's because of how the defendants in those cases are monetizing their models, right? The defendants are typically selling the ability to prompt the models to create new works or outputs that at least loosely compete with the works on which the models have been trained. This goes back to Kevin's quote of training an audio model on sound recordings for deployment in a system to generate new sound recordings, and this is a quote from the report, which aims to occupy the same space in the market for music and satisfy the same consumer desire. And so what the Copyright Office first says is that, well, that's only a modestly transformative use. It's a commercial use. It uses all of each work in the training set, and it does result in market harm if you include dilution as a kind of market harm. So the report, I think, can help potential defendants who may be doing other things with generative models, right? The office says there are lots of things that can be done with models that are far more transformative in the sense that they have a different purpose than the purpose for which the training works were originally created. So examples it gives include translating emails, right? Nobody has ever sued Google Translate for a copyright violation, even though they're using machine learning to develop their translation device. Correcting grammar, providing interactive foreign language instruction, removing distortion from audio tracks, providing automated content moderation, something Kevin also mentioned, right? Those are all uses that do seem to be have more distance between those purposes and the original purpose of creating the works. And that's where I think if defendants who are doing those kinds of things are sued, they can point to the Copyright Office and say, wait a minute, we're not doing this monetizing the prompting business. We're doing something else.
Yeah, and absolutely. So that gets to my next question. And quickly, I want to ask all three of you, how influential do you think this Copyright Office report is going to be in the legal and policy debates over generative AI training? And so, Kevin, I'll start with you. How influential?
I think it will have noticeable influence on policy and legal debates. It's already been noticed in litigation as supplemental authority. And interestingly, the defendant in that case, Meta, did not challenge or object to it. It's being talked about and reviewed favorably by legal scholars and copyright bloggers. I've seen some criticisms by a few groups that sort of represent AI companies, but these are really people who think that there should be like a blanket fair use exception for all AI training, and that's not really how it works. I think the big question, I guess, is the future of the report in its pre-publication status. If there's a registrar appointed who disagrees with its finding or decides to make substantive changes. But I think even if that happens, the original report would continue to have influence because people in the policy and legal worlds would understand that the original took a balanced and thoughtful approach, and then perhaps things happened afterwards that were more based on politics.
Yeah. Okay, Bob, same question.
Yeah, I think it will have influence. I think largely because it is a very thorough look at things, and it does take into account all comments on all sides. It's not like singling out comments on one side and ignoring the others. I do think that the degree of influence may have something to do with whether the first decisions in these cases cite it or not. They might go off in a different direction. And then I think there's going to be some path dependence involved, probably even at the appellate level. So, that's another reason why the Copyright Office may have been looking to get this out on time, because if they issued this report after the first decisions had already been made, then I think the influence is less. And I will say, as one last comment, as Kevin mentioned, when they Copyright Alliance submitted their comments back in 2023, that seems like eons ago in terms of the development of generative AI. By the time this issue gets up to the Supreme Court, we may be thinking, oh my gosh, the facts have actually changed from when they were way back in 2025. Remember back in 2025 when we were talking about this? Some parts of this report may have limited lifespan simply because of the change, both in the technology and how it turns out to be monetized.
Okay, Reagan.
Yeah, I mean, look, the report is out there. I think it has the potential to be fairly influential. It's a well-researched and documented report that, I think genuinely tries to grapple with the different angles and nuances in copyright. It doesn't suggest a one-size-fits-all solution. So, and it is, Bob, as you've mentioned, there's a lot in there and it's changing all the time, but I think people will take from it what they find, persuasive and helpful.
All right, so I see that our hour is up. And so I just want to thank all three panelists for taking an hour out of the day to talk about copyright and generative AI training. I really appreciate you being here, and it's a fascinating discussion, and I'm curious to see how these lawsuits go. And so with that, I'll close out the session, and thank you and goodbye, everyone.